All right, so we're here on a contempt enforcement motion. However, I don't see any exhibits from either side.
First, Your Honor, we're not seeking contempt, so I just want to make that clear. That's not something we're seeking. It's not in our petition or in our order. Number two, we did have a status conference with Judge Lee last week, and myself and Ms. Smith, both sent exhibits to Judge Lee.
Okay, she didn't send over, and I spoke to Judge Lee. She said that you all never, you discussed some exhibits back and forth and you objected to some exhibits, but she never received any exhibits to finalize what the admitted exhibits were.
Oh, I thought we had reached an agreement on exhibits, and then Judge Lee had said that hers, Ms. Smith's exhibits that I was objecting to were admitted, and that you could make the determination based on my objections. But we did send them. Would you like?
Yes, ma'am.
She needs to. What she would have needed is an email with all of or both of your exhibits.
Yes.
That you agreed to, because without exhibits, I can't move forward. Well, I mean, we can move forward. You just can't use exhibits.
I'm glad to move forward today, Your Honor.
Okay.
Well, we want to move forward as well, but I'm happy to resend the exhibits. I saw Ms. Smith's exhibits come through. I saw mine come through, and we told Judge Lee on the Zoom which ones we were okay with.
Okay. Well, before you even do all that, your client, Mr. Kincaid, he's the moving, correct?
Correct.
All right. And this is an enforcement. Let me make sure I'm looking at the violations correctly. It's 6 violations, right?
Yes.
And you're not trying to hold her in contempt. So you just want, what is it that you're asking the court to do? Because I'm not clear from your motion.
Yes, ma'am. So we're not asking for contempt. I don't believe we have anything under the family code that allows for contempt, but we do have some items that need to be returned. We've got some funds that were misused that need to be repaid to Mr. Kincaid. And then there is a Jeep Grand Cherokee that needs to be transferred. The title needs to be transferred into solely Ms. Smith's name. That still hasn't been done. And then really just an admonishment to follow the order that she agreed to.
Okay, the power of attorney, do you have it?
No, ma'am. Miss McKnight is not my lawyer anymore.
Okay.
And I feel as she just hasn't represented me since we came to the settlement agreement. If Mr. Kincaid would simply give me the title per your order, I will take care of that immediately. All he has to do is hand it to me.
And counsel, the reason I was asking about what it was that you wanted the court to do, because your motion is not even specific enough for me to find that she even violated the order. For example, violation 2 reads, mother has violated the order by consistently being late for possession exchange times without notice to father. That doesn't put her on adequate notice pursuant to the slaughter case about what she's supposed to do.
I think there, Your Honor, we're just looking for an admonishment on going forward to please be on time with possession.
I'm not exactly aware of the dates and times they're speaking of.
Yeah, and that's another thing and thank you for saying that. Pursuant to Slavin, it has to allege date, time, manner. None of that is in here.
Okay, that's fine for the late times because we're not looking for any actual relief on that other than both parents need to be on time. So if we want to move forward without that one, we're happy to do that.
Okay. Well, counsel, in
the prayer, Your Honor, it does say what we would like to have done.
I understand, but before we even get to the prayer, we have to get through your violations and your violations.
May I speak to?
Hold on one second.
Yes, ma'am.
I don't even know how you would get there.
I'm
Your
not,
violations are not even sufficient to put her on notice for the court to even grant what you're asking me to do. Does that
in
make
which
sense?
way other than number 2?
Well, I can't tell you that. I just can tell you by looking at it, is really going to be hard for the court to find her in violation when they're not specific enough to put her on notice. Have you all had an opportunity to discuss coming to any type of an agreement regarding the motion?
I have tried many times, and I know that Mr. Kincaid has tried many times to settle this matter with her. I've not received any response to our settlement offers, and I don't know if Mr. Kincaid has, but I know that it hasn't gotten anywhere.
Your Honor,
Okay, go ahead.
I have not.
in my defense,
Well, you don't know.
well, this settlement offer is adding so much more to these violations. I am at the mercy of the court right now because he literally wants so much more than what they are bringing me here today for. So no, I am not going to agree to a settlement to get rid of these items. And it just, the settlement agreement is beyond these violations.
Okay, you all both understand that an enforcement only allows me to enforce what has already been ordered, right?
Yes, Your Honor. The problem is that's the first I'm hearing of that. Up until this point, I've had no idea what she's not okay with. So the discussions, to answer your question, no, there's not been a discussion
That's
because
exactly
we've just
what
sent
I-
offers.
You all can't talk over each other. This what I'll do. Okay, I will allow you all, if there's a conference room back there, if you would join the Zoom, I can put you all in a breakout room. That way, because the council, she just said this is her first time hearing it. Now, you may have had conversations with Mr. Kincaid. I don't know if it was probably translated to him, to his attorney, the proper way.
Right, well, I just refuse.
Okay, so even after her saying that
Yes.
this was her first time hearing you say that, you're still refusing?
There have been plenty of communication.
No, it's a yes or no. Are you still refusing after
Yes.
what she just said?
Absolutely.
Okay. Joey?
Your Honor, if I may, I would like to talk to her about what we could do to resolve this. I really would. I haven't
would
had the
like-
opportunity to talk to her.
I would like the opportunity to not have discussions with them anymore and focus on the violations at hand.
Okay. All right. So counsel, you heard that?
I did hear that, but that is what the settlement discussion would be about, is how to resolve the violations in front of the court today.
If I can speak to the violations, I think that we can agree. And Your Honor, my suggestions, I do think moving forward would be somewhat of a resolution.
Okay. So could you do this for me?
Yes.
Right? Could you speak to counsel? And it'll just be you and her in the breakout room.
Mhm.
Okay. Could you speak to counsel specifically on addressing these violations?
Mhm.
Anything else, you all can table that for right now. I just
Exactly.
want you all to speak to these violations. And I'm not trying to force anyone out of having a hearing, right?
Yeah.
I don't want either of you to think that that's what I'm trying to do. However, I do believe that as best you all can work together on a settlement, it just makes it better for everyone versus me telling you to do something, then you're mad because you really don't want to do what I told you to do. You'll, at least if there's an agreement, you're more inclined to follow it if you all agree to it. Does that make sense?
It does make sense, Your Honor.
Okay, so you have the Zoom app on your phone?
I do.
Okay, so let me give you the Zoom code so you can join, and then there's a conference room. It's 2 conference rooms. You can go in either one of those and go on the Zoom, and I will add you to this breakout room.
Yes, ma'am.
Let me see. And Mr. Kincaid, you're just gonna hang out here with me, okay?
Yes, Your Honor. Appreciate it.
No problem. Move to main session. Do you see me moving you to main session? Okay. So let me take you off. You can log off Zoom. All right. Okay, Attorney Hernandez, you're back.
Yes, ma'am. We were able to reach some agreements, and then we just have two things for your honor.
Perfect. You see how that worked? Okay. So let me pull your case back up. Hold on one second. And you all have to bear with me because the system is crashing on me left and right.
Okay.
If you all needed to go to the restroom, it's right when you got the doors, it's to the left and you make another left where the elevators are. You're welcome. Okay. All right. So, Joy, I can't remember. Did we? No. Okay, that's what I needed to know. All right, everyone ready to proceed? Mr. Kincaid, would you remove yourself off mute and turn your camera on, please?
Yes, ma'am.
All right. We're on the record in cause number DF 2306791. Counsel, will you please announce for the record?
Alyssa Hernandez on behalf of petitioner Drew Kincaid.
Thank you. And ma'am, would you please state your name?
Amanda Smith.
Would you pull the microphone a little closer to you?
Amanda Smith.
Okay, and you are the respondent in this case, is that correct?
I am, Your Honor.
And you are proceeding representing yourself, is that also correct?
I am, Your Honor.
All right. Would you all raise your right hands? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
Thank you.
Yes,
You
Your
may
Honor.
lower your hands. So we're here on a petition for enforcement of a final suit affecting the parent-child relationship. The court encouraged the parties to speak to each other in one of the conference rooms, and it has come to the court's attention that there has been some progress, and you all have made some agreements. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Yes,
All
Your
right.
Honor.
Thank you. Attorney Hernandez, go ahead and read the agreements into the record.
Sure. And if Your Honor would like, I can not preview, but we have some agreements, and then I can let you know the remaining issues if you'd like, or I'm happy to just read them if that's all you're asking for now.
You know what? Let's do it that way. Tell me the issues that remain outstanding.
Sure. So one of them is not an issue for you to really decide on, but I think both parties would benefit from Your Honor's clarification on what their order means on what a designated competent adult is. That has caused a lot of issues in their co-parenting, parallel parenting relationship. And I think both of them are seeking clarification on that.
Okay.
And then second, we are requesting attorney's fees on the basis of Ms. Smith's refusal to have settlement discussions with us.
Okay. All right.
Everything else has been agreed to. We've reached agreements.
Okay, perfect. So go ahead and read the agreement between the parties into the record.
Sure. So both the parties have agreed that Miss Amanda Smith will provide all of the child's Calvin Klein underwear, all of the child's Calvin Klein undershirts, all of the child's Nike socks that are in her possession to Mr. Kincaid by 5 p.m. on Friday. She is going to pay $20 to Mr. Kincaid also by Friday at 5 p.m. for a pair of missing Nike shorts, excuse me. She's also going to pay Mr. Kincaid $50 for the misappropriated trust funds that were used by Friday at 5 p.m. I am going to send the Texas DMV power of attorney form to Ms. Smith. She's going to fill that form out today and return it back to me for Mr. Kincaid to execute, and she will have the title to the Jeep transferred into her sole name by Friday. Lastly, the parties agreed to include a clause in the enforcement order, a mutual recommitment that they will both follow the final SAPSR order on a go-forward basis.
Okay. And Mr. Kincaid, is that your understanding of the agreement?
Yes, Your Honor.
Thank you. Ms. Smith, is that your understanding of the agreement?
Yes, Your Honor.
Okay, so the court accepts the agreement between the parties. And counsel, I'll be relying on you to give me an order that not only fleshes out the agreements between the parties, but whatever the court is going to consider on the attorney's fees, okay?
Yes, ma'am.
All right, so competent adults. A competent adult is just what it sounds like. Someone who is able to drive a car, put the child in a car and make sure that the child is retrieved from one parent, take the child to the other parent. That's the competent adult. If it can't be anyone who is, when we say incompetent, so someone who is incapacitated mentally, right? That wouldn't be a competent adult. A competent adult does not mean that that person does not have a criminal history. I'm not saying that you all are designating anyone that does, but I just want to make sure it's clear. You know, if someone has a criminal history, if there are no orders limiting, legal orders limiting a person from being able to be around children, they're going to be considered a competent adult. It can be a new girlfriend, it can be a new boyfriend, it can be a new spouse, it can be a best friend, it can be a relative, it can be the preacher at church. It can be any of those people that I listed, as long as they are what's considered competent to make sure that the child gets from point A to point B. Yes, ma'am.
So in this case, Judge, it was a car service.
What do you mean a car service, like Uber?
No,
No,
like
Your Honor.
a car. It was a private vehicle, and a 17-year-old nephew, or Drew's brother, youngest brother, 17-year-old in a car service, and he was not being directly delivered to his father.
Okay, the car service would, okay.
I can respond, Your Honor, if you'd like, or we were just seeking clarification, so I don't know that any argument is necessary, but if it's helpful, I can
want to
respond.
hear from Mr. Kincaid, actually.
Oh, sure. Go ahead.
Okay, Mr. Kincaid, clear that up for me.
Yes, Your Honor. So David is a family driver for our family, has been a family driver for our family, meaning not just me, but my siblings, for my father. Miss Smith has also rode with him many times, with Ronan in the vehicle, I may add. I did send my little brother also with him, just to make sure there was family there. And they were going to my dad's house, where I was going to be a little bit later that day. And she refused to release him to a competent adult that she is very aware of, has ridden with many times. Ronan has ridden with many times. She knows exactly who this person is. He has all the certificates from the state of Texas to drive. He is a limo driver. He's not an Uber driver. He is a family friend who is our family driver.
Yes, ma'am.
You paid him, correct, to do that?
Yeah, okay, so we're not going to get into all of that. It was
He
just,
also wasn't delivered to, Drew was not there. And why, if he was going to Drew's dad's house, Ronan's grandfather's home, where was his grandfather?
okay.
Why is there a 17-year-old? So David is dropping off a 17-year-old and a 7-year-old to a house that I don't know if there's when an adult is going to be there.
Okay, so I can answer that for you. And I'm just going to say it right out because I don't know any other way to say it. It's none of your business.
Okay.
When his child is in his possession,
Okay.
it's none of your business where his son goes, as long as he's somewhere safe. Same thing with Mr. Kincaid. It's none of your business where your son goes, as long as he's with someone that mom has designated him to be. And the reason I'm answering it directly like that, because I don't want either of you to overstep and think that you have control to tell the
I
other
appreciate that, Your Honor.
what they can and cannot do with your son. And you don't want me to do that because quite frankly, you all are the parents. I don't want to be the parents. I have a 17-year-old. I have a 16-year-old and a 6-year-old. And trust me, if I could give them to either one of you, I would, because kids are expensive, right? But I know you don't want your kid either. I want you all to co-parent as best as you can. So yes, as long as he is safe and he is transported where the other parent that's receiving him, he's supposed to be, that's all that matters.
Okay.
Competent adult. And from what it sounds like, this is a competent adult. Your son has gotten back to you safe. And that's all really that I'm concerned about.
At the time, there was an inconsistency you know, with how both of us read that.
Right.
So, I mean,
And I understand, and that's why I'm here. So I can clear it up for you all.
Thank
So
you.
now you all should not have any issue moving forward.
Okay.
Okay?
Yes, ma'am.
All right. The next thing, attorney's fees. What is it that you're asking for in attorney's fees, counsel?
We're just asking for a portion of our attorney's fees to be paid, considering Ms. Smith's, even her own admittance today that she refused to speak with us on settlement negotiations, even from the beginning when we filed this case.
Ma'am.
Okay. So let me just say this. Attorney's fees are something that the court, I can't speak for any other judge, but it's something that the court utilizes to ensure that orders are followed, right? I don't want to use it in a punitive way when someone is choosing to do something that they absolutely do not have to do. So mediation, any settlement, well, you all weren't ordered a mediation, so let me not use that word. Any informal settlement agreements, if either of you choose not to do that, you absolutely have the right to do that. And I don't want to make attorney's fees punitive, because at this point, I think that's what it would be, because she didn't agree to participate. I will say, even she told me no, but she did participate today. And that's all the court can encourage anybody to do. So I don't want to do that to anyone. So I'm going to deny attorney's fees. I just want to make sure that both parties understand this, though. If for any reason you come in court on a motion for enforcement, I just want to make it clear that you understand that attorney's fees is a request that the court can't entertain, okay? The court is just choosing not to do so in this particular situation.
Okay, thank you, Your Honor.
Okay, so
Thank you.
if you give me an order, Attorney Hernandez, I would appreciate it. How much time do you need to circulate the order?
I think I heard you give the last two cases 2 weeks. I think that's fine.
Okay, so I will add you on the same date as everyone else. It'll be November 7th, 2025 at 9:30. That'll be in front of Judge Lee. Now, if the order is circulated and signed, you all don't have to worry about that date at all. It'll just go away. But if it's not, then you would need to log on to the Zoom that day with Judge Lee and let us know what's going on, okay?
Okay.
Let me give you
Sounds
all the dismissal code when you're ready.
I'm ready.
Okay, Ms. Smith?
Do I need to write it down?
You can put it on your, like a note on your phone.
Yeah.
Okay, it's 961-1106-4392.
And to be clear, this is how I would log into the Zoom on that day on November?
Yes.
Okay.
If you need
If
that
we
date.
needed to.
Yeah, you
Okay.
may not need the date
Yes, ma'am.
because you all came to an agreement. And let me just reiterate again, I appreciate you, Ms. Smith, even listening to me. You absolutely did not have to. I can't force you to do it, but I appreciate you going down the hallway and speaking, Mr. Kincaid. I appreciate you all for coming to some sort of an agreement, because like I said, when you agree on your own, it makes it easier for you all to follow the order. Anything
Yes,
else,
Your Honor.
please?
No, ma'am.
No,
Okay,
Your
well,
Honor.
free to leave. Thank you so much.
Thank you.
Thank you.
Thank you.
You're welcome. All right, State of Texas versus Eric, is it Medellin?